screen here. Hopefully this works.
Looks good.
Is this looks good?
Yeah.
Awesome. So, like my wonderful host has said, my name is Chris Posner. Thank you all for coming. Obviously, today we're talking about covenant enforcement, which for a lot of you is unfortunately your day to day here. You move into these communities because you want established rules. You don't want, your neighbor setting up a chicken coop unless you're in an association that allows it. Well, surely that's in your documents. But for most people, you don't want the chicken coop. You don't want people putting their garbage on the street all days of the week. You want structure. That's why a lot of this is important because you want to enforce your rules, you want to enforce your covenants, and if you don't enforce them, you might lose your ability to enforce them. So even if your documents say that something is not allowed, let's say you have a year or two where a board decides not to enforce those things, they want to be the cool board. 2 years later, you come in on the board and all of a sudden you can't enforce. Well, these are things you want to avoid. So a lot of this is important. A lot of this is stuff that you see on a day-to-day basis, and you might think to yourself, how do we deal with these? Well, with this class, I'm hoping to give you the tools you need. So, covenant enforcement. When I refer to covenants, those are the rules we live by when we move in to a community, whether we're buying, we're renting, we're just a guest. It all applies. The moment you step onto community property, you are bound by those rules. A lot of these things also encompass ARC applications. Let's say, your neighbor wants to put in that chicken coop. Well, they would have to, some communities require the board to approve those alterations. They would have to submit an application. Sometimes they just put it up without getting approval. And now you need to enforce your ARC rules and tell them to take it away. This also includes things like age restrictions for 55 and up communities. You want to make sure you don't lose that 55 and up classification because you've let too many people under 55 live within the community. Also, pet restrictions. Some communities don't even allow pets, yet you see pets all over the place. You want to make sure that you're enforcing while also being careful just in case you get what's known as an accommodation request. For example, someone might say, oh, this isn't my pet, this is my emotional support animal. Well, you want to be careful and know how to deal with those things so you're not getting into trouble. Also, things like sales and leasing, that means reviewing applications, approving and denying applicants, guest/occupancy restrictions. Again, if a guest is living with the community for a certain period of time, they might become a tenant, which requires approval. Parking and vehicle restrictions, you might not allow commercial vehicles on your property. You might not allow, vehicles with like a bunch of ads on the side. And finally, the kind of catch-all is nuisance conduct. These are kind of a high-level example of things you probably see in a day-to-day that I hope to give you tools to enforce down the road. Now, obviously, the first step of enforcing your rules is to put the people on notice that they're violating the rules. So you want to make sure that when a violation is observed, you send a letter by mail or hand delivery, or if this owner has agreed to receive things by email in writing, you send this letter to them saying, hey, you're violating section so on and so forth of our declaration. It says no pets. We see you have a pet on the property. You need to relocate that pet within 14 days, or else we'll proceed with further enforcement. Thank you. You send that letter to the owner or any tenant or guest at the property, and you kick off the enforcement process. Obviously, if people don't know what's going on, you can't really proceed with enforcement. So the first step is always sending that letter. Oh, and you also want to make sure you explain in that letter how they can cure the violation. So in the pet example, you can say, hey, you need to rehome that pet within 14 days. You always want to give a reasonable time frame for these curing of violations, and determining what's reasonable, it's kind of hard, but use your best judgment. And if someone seems shocked that you only gave someone 2 days to paint their home, well, it was probably not reasonable. So at the end of the day here, only a judge can really determine what constitutes reasonableness. Now, after this notice is sent, let's say you send this letter to Joe saying, hey, Joe, rehome your dog within 14 days, and they don't do that. The dog is still there after 14 days. Joe has not responded. What do you do? Well, the next step is looking at your suite of enforcement options. You can proceed with fining. You can suspend Joe's use rights, not for the pet, but let's say Joe hasn't paid their assessments for over 3 months and it's over a certain dollar threshold. Well, you can even suspend his voting rights. There's self-help for certain situations. Although for certain violations you don't want to exercise self-help, I wouldn't recommend just going on the property, snatching the dog, and you know bringing it to a shelter. But self-help, as I'll explain later, can be used in certain circumstances. And then when all else fails, there's pre-suit mediation and non-binding arbitration, which again, I'll explain later. And then if that fails, well, then you're going to court. And that's what litigation is. So fining. Generally, fining is the way most communities want to go before they get their attorney involved, although some communities aren't set up to fine. So fining, all associations have the authority to fine. So even if it's not in your governing documents, the statute 718 for condos, 720 for HOAs provide the authority for boards to levy fines for violations. And again, it doesn't have to be in your governing documents like certain other restrictions. Now, for condos, fines cannot exceed $100 per violation, which is generally per day, or $1,000 in the aggregate. So what I mean by this is, let's say with Joe, you've sent him a letter, and let's say Joe has, trash or debris. He just did a remodel of his home and he's left debris on his front yard, which is against the rules of the association. Let's say you've observed him keeping that debris on the lot for more than 10 days at $100 per day. That's a $1,000 fine right there. For certain other things that can't be cured, let's say Joe is smoking a cigarette in front of the elevator in the building, which in most cases would be against the rules. Well, you saw him do that, that's $100 for that violation. Now, for condos in particular, these fines cannot become a lien on the unit. So if you're going to end up levying these fines, they should be kept on a separate ledger tied to the unit so that, let's say the owner goes to sell their unit and you get an estoppel request, you can include both their assessment owed as well as their fines. But again, those fines could not be the basis for a lien, meaning you wouldn't turn those fines over to your attorney to pursue foreclosure on for condos only. Now, for HOAs, you have the same dollar thresholds, $100 per violation, $1,000 in the aggregate as a cap. However, if your governing documents provide a different cap, so let's say you have $500 per violation or per day and $5,000 in the aggregate, that is allowed only for HOAs. Now, on top of that, let's say you fine Joe $2,000 for various violations. If the fines are more than $1,000, that can become the basis for a lien, meaning we can go through the normal collection process and even foreclose on Joe's house for the violation. Again, condos are capped at $100 per day, $1,000 in the aggregate, cannot become a lien. HOAs, if the documents provide otherwise, you can increase those amounts. And if it's more than $1,000, it can be a lien on the property. Now, both condos and HOAs follow a very similar fining process. Again, you send your notice, the board at a duly noticed meeting agrees to levy a fine against the property, and then following that board meeting, a follow-up notice is sent to the owner or occupant, guest, tenant, so on and so forth, basically saying, hey, the board has levied a fine, your violation is still ongoing. On this date, our fining committee is going to meet to either approve or reject the fine the board levied, which is $1,000, and it'll list like the location, date, and time of that meeting. Now, again, it's the same for both HOAs and condos. This fining hearing, which I'll go into more detail in a little bit, cannot be less than 14 days out from the date the letter is received and not more than 90 days. So I already went over what the fining notice should state, but again, it should really describe the violation, the specific section of your governing documents or rules that mandates the rule, how to cure it, and then again, the information regarding the fining hearing. And the committee meeting can be by Zoom, can be by telephone. You just need to be able to give them some way they can easily access the meeting. And that owner can attend the meeting with a representative, like an attorney. The guest can also bring witnesses. It's pretty broad who can attend those hearings. Now, the hardest part, at least that I find for our clients to even proceed with fining, is to actually form this fining committee. This is hard because you need to have at least 3 members, meaning members of the community, generally owners, appointed by the board who are not officers, directors, or employees of the association or somebody, in their family. So basically 3 independent members. And I have found that a lot of communities struggle to get these people because the faces of the fining committee can be people don't tend to approve of the fining committee. I don't understand why. I mean, you're kind of scapegoats at that point, I guess. But either way, it is a necessary part of being able to actually proceed with these fines or even suspension of use rights, which I'll get into later. Again, you need to have three independent members who are not related, not officers, directors, board members, or employees, or their family members, or really anybody related to the board. You want as impartial of a committee as possible. And if you can't form that committee, well, then you can't proceed with fining or suspension of use rights in most cases. And this is the same for both condos and HOAs. Now, let's say you have your fining committee. The sole purpose of the fining committee is to either approve or reject the fine or suspension levied by the board. They can't modify the amounts. So let's say in Joe's case, he's had debris on his lawn for more than 20 days. The board levied a fine of $2,000. Joe shows up, he gives some excuse for why it's been out there, and the board or the committee can only approve $2,000 or reject $2,000. If they approve it, we can move forward. If they reject it, well, if the board wants to pursue further fines, they have to start the process all over again. Now, this notice for condos, must be sent by mail or hand delivery. And on that letter, it basically explains, hey, at the fining committee, they approved the fine in 2,000 amount of, $1,000 because it's a condo. You have to pay within 5 days of your receipt of that notice. And if they don't pay by the 5 days, well, then we put it on that separate ledger and keep track of it. HOAs, within 7 days of that fining meeting, the committee has to send a notice by mail. Email is allowed, again, if the owner has consented to email notice, but I will always recommend doing by mail just in case. It's basically saying the same thing. Hey, at this fining committee meeting, the fine was approved. You have the difference for HOA condos. You have 30 days in an HOA context to pay that fine. And if they don't, then it goes on their ledger. Because again, HOA fines can become liens. Now, one important thing to note is if the violation is cured before the hearing or before the date the fine is due after it's been levied by the fining committee, the fine is basically erased. At the end of the day here, we are trying to achieve compliance, not penalize people. Obviously, the fines are there to kind of dissuade people. But again, at the end of the day here, we're not here to make money. We're here to make sure people comply with our covenants and rules. So again, if they cure beforehand, you're done. Now, again, for condos, it's a 5-day window to pay back the fine or to pay the fine after the notice is sent, while HOAs, it is 30 days, at least 30 days. And if you have your attorney involved, please note that any attorney's fees the board accrues before the fine takes effect is essentially a cost of doing business. But any attorney's fees incurred after the fine is due, you can start accruing attorney's fees in the event, let's say you go to court over it. Those attorney's fees you incurred at that point forward can be something your attorney could try to recover if you prevail in litigation.
I'm just going to mention
Now,
something real quick before your next slide. For Janae and others, I'm only answering questions that don't require me to have the ESQ after my name. So that questions that are teetering on legal in nature on the course material, Chris will cover as many as he can after the end of the session. I'm only answering questions that you don't need to be an attorney to answer. Chris, back to you.
thanks, Jeff. Yeah, I incurred all these student debt just so I could answer certain questions. So leave them to me. Anywho, so HOAs have some differences, obviously, but there's certain things regarding enforcement that you should keep in mind, particularly regarding new legislation, new-ish, I believe it's 2024, where HOAs are not allowed to levy fines or suspensions for two particular areas. One, leaving your garbage can on your street or at the end of your driveway within 24 hours before or after garbage pickup time. So if, let's say, garbage pickup's on Wednesdays, in the past, if an owner put their garbage can out on Tuesday and didn't pick it up until Thursday, that's a violation right there, and you could levy a fine for it. Now it's more than now if they leave it in on Tuesday or Thursday, it's fine. But let's say they put it out Monday, which is more than 24 hours from garbage pickup time. Well, now we can pursue the violation. There's also holiday lights where, let's say you have a rule that says, holiday lights have to come down by January 15th. If an owner has something up to January 16th, you can't just start the clock and say, hey, that's a violation. You have to send a notice saying, hey, our rules say January 15th is the deadline. You have a week to take them down. If you don't, we're going to send our first violation notice and proceed with enforcement. A lot of times when I see very specific things like this saying you can't enforce, it's probably because someone in Tallahassee got a violation for this and said, I don't want this to happen. It's not fair. And then they put it in the law, and now we can't really enforce certain things. Suspension of use rights. So in addition to fining, you also have the option to suspend someone's use rights. Now, this is mainly for communities that have actual amenities and ways to stop owners from going to those amenities. So let's say you have a clubhouse that requires a key fob to get in. If you go through your suspension of use rights process, which as I'll get into is essentially the same as fining, you can deactivate that key fob until the suspension is lifted. You cannot, however, suspend someone's ability to even enter their unit or enter the community. They have to be able to get to their home. You can't stop them from using their parking space. You can't stop someone from using the elevator. And I'll go into more details about that. But again, like fines, an association can suspend those use rights. One, for violations of the rules, just like fines. However, there's an additional option where if an owner is delinquent for more than 90 days in the payment of any fee, fine, or other monetary obligation like assessments owed to the association, the board can suspend their use rights. And again, this is for common facilities. You can't stop someone from using their limited common elements like their balcony, but you can stop someone from using the gym, pool, or clubhouse. And another way to really annoy people is you can turn off let's say you have one of those guard gates that has a visitor side and a guest side. You could deactivate the owner side and the visitor side. You could deactivate their owner side entry and make them go through the visitor side as well. That really tends to make people angry. But again, you should be complying with your stuff. So as I was saying earlier, use rights cannot be suspended for limited common elements, elevator access to the unit. You can't stop them from going to the hallway that their unit is in. You can't shut off their power. You can't, prevent them from using their assigned parking space. Same thing for HOAs. It's really about the common use amenities that you want to suspend. So if your community doesn't really have those things, or let's say you have a pool that just anybody can enter easily, there's really no point to suspend use rights because there's no way to police it, and there might not be anything really worth suspending over. Now, again, as I said earlier, if someone is delinquent for more than 90 days, they actually can go around the fining process that I mentioned earlier, and just at a board meeting, the board can vote to basically suspend someone's use rights if they have been delinquent for more than 90 days. The board still has to notify the owner, but at the meeting, they can look through the list of owners who are delinquent, say, hey, we're going to suspend the use rights for, units 101, 102, lot 1, lot 2, whatever, so on and so forth. They have been delinquent for more than 90 days, make a motion to suspend, approved, yada, yada. And then after that meeting is over, a notice should be sent by mail or hand delivery, or again, if someone's consented to email notice in writing, you can send by email, basically saying, hey, at this meeting, the board suspended your use rights for, if it's for fining or for delinquency, until the delinquency is paid. So if someone hasn't paid for some time, the only way to get their use rights to the clubhouse back is to bring their account current. Now, for non-monetary violations, again, just for violation of the rules, if instead of fining you want to suspend instead, it's the exact same process for the fining committee. They can, in fact, basically the fining committee does the same exact thing. They would approve or reject the suspension and the length of time of the suspension. And if approved, it would go into effect and the same notice is sent to the owner. If it's rejected, well, that's the end. It's the exact same thing for HOAs and condos. You send your first notice, the board levies a suspension. A second notice is sent to the owner or tenant or guest saying, hey, the suspension was levied and for this amount of time for your violations. This is the date of the hearing, which can occur less than 14 days or more than 90 days. The committee meeting happens, and if the suspension is approved, you send your notice, either 5 or 7 days, depending on if you're a condo or HOA, and the suspension takes effect, if approved. Again, this is the same exact committees. I'm going to skip going to these slides. Again, it's basically the same information. Now, suspension of voting rights is a bit more complicated. An association can suspend an owner's voting rights, again, if they are if they're delinquent for more than 90 days. Again, if they haven't paid a fine, fee, or other monetary obligation to the association, like assessments, the board at a meeting could suspend their voting rights. Now, it has to be more than $1,000 that's owed to the association before they can do this. But once you cross that threshold and it's been more than 90 days, well, now the board can consider suspending someone's use rights. You have to provide an owner 30 days notice before the voting right suspension takes effect. And if it's at least 90 days before the election and the board's going to go through a list of people to suspend their voting rights, you have to give that owner notice that, hey, because of your delinquency, the board will, suspend your voting rights. So is a bit more strict on the deadlines to do these things. So if you're considering doing this, I would suggest speaking with your counsel to make sure you're following the right deadline. Again, I went through this already. When a owner's voting rights are suspended, they are essentially considered they don't exist. So they're not counted for quorum purposes, not counted for election purposes or to approve an action. So if let's say you need 50 units normally to approve something, you now only need 49. And again, that suspension of voting rights ends upon bringing the delinquency current. So one thing to keep in mind that certain restrictions, some things you can do like voting rights suspensions, depending on your documents, may have to be in your governing documents. There's a concept known as Kaufman language, which I'm not going to go into too much detail because that in itself could be a multi-hour course longer than this one. And it's something we're kind of still, all of us attorneys are still kind of arguing about to this day. But essentially, depending on when your declaration was recorded, may impact what rights you have under Chapter 718 if you're a condo or 720 if you're an HOA. This is one of those things where talk to your legal counsel or reach out to us afterwards if you don't have legal counsel to have us explain and make sure what your rights are while considering this Kaufman language concept. And again, it's pretty complicated, so speak to your attorney or reach out to us after the class. Now, self-help. So self-help is essentially the requirement or right of the association to basically go into a unit or onto a lot and just cure the violation themselves. Generally, this will come about, let's say, going back to my initial example with Joe and his debris on the front yard. Let's say the documents for that association say, hey, if an owner isn't in compliance, the association can go onto the lot and do whatever actions necessary to bring the lot into compliance and, charge any amounts incurred to the owner. So if you have that in your declaration, well, this would allow you to go onto the lot, pick up the debris. Let's say you had to hire a company and it costs $300 to do so. You can charge Joe on a separate ledger. Now, if your documents allow you to make an assessment for that charge, and again, check your documents for this one, it could become a special assessment, which can become a lien and lead to foreclosure. But with self-help, there was kind of for a couple of years, and depending on where you're located, so this is the kind of thing that, again, talk to your attorney, where in some instances, you might have to exercise the self-help authority no matter what. Even if this person is crazy and you have fear for your vendor's safety, as crazy as this sounds, you might still have to attempt self-help. Because when we're dealing with enforcement, and let's say we've gone through the fining process, done all these things, and the owner is still not complying, well, when we file a lawsuit, we are looking for what's known as injunctive relief, which is an order from the court saying, hey, cut it out, or, we're going to put you in jail, we're going to do other fines. We're basically asking the judge to play parent here and tell someone to cut it off. Now, to get injunctive relief, one of the things that the attorney has to show on behalf of the association is there's no other remedy available under the law. So courts have held that association with self-help language in their documents actually do have a remedy. So under that analysis, these courts have held you have to try your self-help before you come to us saying there's no other remedy. So for years, we've been telling clients, hey, you need to try before we go, to court over this. However, in recent years, this has been changing. And unfortunately, there's not really agreement between where you're located. So certain courts of appeals have held that, self-help might not be warranted in some instances, and the association can just go straight to asking the court for help. Again, speak to your attorney to see where your area is on self-help remedies, and also to confirm whether your documents even have this self-help requirement in the first place. Because if it's not even in there, well, you don't even have to try. Now, dispute resolution. So there's a lot of slides on this, so I'm kind of going to combine HOAs and condos because for the most part, they're the same. So HOAs and condos have two options after this whole violation process has fallen through. So even if you don't have a fining committee, you send that first notice, and let's say they don't comply. Well, sometimes our clients have our office send a letter. We tend to find that people listen if there's a letterhead from an attorney's office saying, hey, cut it out. But if it looks like we're proceeding to court on this, well, our next step is what's known as pre-suit mediation or arbitration. So both arbitration has to be started with a petition to the Division of Florida Condominiums, Timeshares, and Mobile Homes, which is called the division for short. And alternatively, for mediation, that's really just between the parties to hire a mediator to help everybody come to a resolution. So certain things are not eligible for mediation, and some things have to be arbitrated or just straight up filed in a court of law. Now, there is a couple disputes that require this pre-suit mediation or arbitration. These include things like the authority of the board to take certain actions or not take actions, to alter the common elements or areas. So let's say the board, redid the pool and they didn't get the approval of the membership and that was required in the documents. You would potentially file a pre-suit mediation or even an arbitration petition with the division. This also for condos or HOAs, a failure to conduct elections, to give proper notice for certain meetings, or even to properly conduct meetings, or allow the inspection of your official records or other exercising of rights within as a condo or HOA owner. While there are disputes that fall under the pre-suit or arbitration purview, there are things that don't. So any issues involving title to a unit or the common elements, the interpretation of a warranty given to owners, something regarding like an assessment payment or the collection of an assessment, the eviction of a tenant from a unit. Let's say you claim the board member breached their fiduciary duties to the owners. These are things that you're not required to go to mediation or arbitration on. You can just go straight to the courts and file suit. Now, you might be wondering, why is there a difference? Why do I even need to do this? Well, under Florida law, if your dispute, as I included in this slide here, if it falls under that and you don't go to pre-suit mediation or arbitration, you are forfeiting your right to attorney's fees if you prevail. So for a lot of these disputes and a lot of claims with associations, if you're going to court over it, and a lot of times if you prevail, you are entitled to recover your reasonable attorney's fees and costs. Now, if your dispute is one that requires pre-suit mediation or arbitration and you don't do that first, well, you've just waived your right to attorney's fees. So if your counsel is saying, all right, let's just file suit, and it's one of those things you think might require mediation or arbitration, well, maybe you tell them to put the brakes and review 718 or 720. So a lot of these things with arbitration, and I'll leave it to you to review with your counsel, because in most cases, you're not going to be arbitrating decisions. At least in my opinion, arbitration is quite a hassle. You're spending a lot of money and time on things. When with most times in mediation, we tend to work out a resolution here. In fact, the amount of cases that actually go to court after mediating is staggeringly low. I think it's like 3 or 5%. It's very low. Mediation tends to, solve a lot of issues and kind of cut off the fees and costs here, because once you get to court, it can get pretty expensive. So again, arbitration, you do have to send specific notice, same with pre-suit mediation. But the problem with arbitration here is you have to be very specific and make sure you do everything correctly, because if you do something wrong, you just waste a lot of time and the arbitrator might dismiss your petition. But again, these kind of procedure things are something you should speak with your legal counsel. And if you don't have legal counsel, please feel free to reach out to me and I can go into more detail here. But a lot of this is just excess information that your attorneys can answer for you. And again, at the end of the day here, the arbitrator might still require you to go to mediation. Obviously, if you go to mediation and you don't resolve the situation, at that point, you need to file suit to get the relief you're looking for. A lot more in arbitration. Now, again, as I said earlier, if you don't go to pre-suit mediation or arbitration in an instance where you have to do so, you are forfeiting your right to attorney's fees, even if you prevail in court later down the road. Now, again, HOAs and condos are largely the same when you're going to arbitrate or pre-suit mediation. So I'm going to go right past these to give us more time for questions. Now, litigation. So after you go through the enforcement process, let's say the person doesn't cure, you've already done fines, your attorney sent a letter, you tried going to pre-suit mediation, no resolution is reached. If the violation is still occurring, at this point, you got to file suit. You got to get an order from a judge saying, hey, cut it off. Now, these would be what's known as an action in equity, where you're trying to say, hey, judge, it's not fair that they can do this. Please help me out here. And pretty much, the association obviously can file suit. The owners of the property can file suit. Directors can file suit. Even for certain situations, tenants can file suit. And even developer directors can file suit or be sued. At the end of the day here, you can really sue anybody for anything, but whether you'll be wasting your money, well, I would talk to your attorney first. Again, for most instances for HOAs and condos, if you're filing suit about something in the governing documents or covered under 718 or 720, if you prevail and you did your pre-suit mediation or arbitration if required, you should be entitled to your reasonable attorney's fees and costs. Obviously, this might vary if the judge is not feeling generous or not, but in most cases, you should be entitled to your attorney's fees if you prevail. Now, here's probably the most important part. So when I first started this class, I said it was very important to make sure you enforce your documents and your rules, because if you don't enforce them, you might lose your right to enforce them. Again, one I see happening a lot is these no pet communities. You might have a community formed in like 1972 that says absolutely no pets. Well, 20 years later, we have a board who loves dogs and like, you know what? They're not hurting anybody. And for years and years and years, they let people bring dogs in. Let's say a new board gets on. So wait a minute, I hate dogs. And our rules in 1972 said no dogs. So I'm going to tell people to get rid of their dogs. Somebody goes into purchase and they say, nope, I'm denying you because you have no dogs. Well, let's say they move in and you try to go enforce and say, hey, they have a dog in violation of our rules. You sue them. Well, they're going to have a bunch of affirmative defenses that I'm about to get into that will probably lead to you losing that case. So the first one is selective enforcement. I'm sure for board members and managers, I'm sure you've heard owners scream this after you've gone to enforce something. Oh, I can't have these shrubs on my front lawn. Well, Michael down the road there has shrubs. This is selective enforcement. And they're not wrong. A lot of times, if there's a violation occurring in other parts of the community, but you're only enforcing against one person, that is known as selective enforcement. So it is imperative that when you are enforcing these things, you are uniformly enforcing them. Any ARC guidelines, any rules, any restrictions, sales and leasing criteria, you want to make sure it's the same for everybody. Because the moment you deviate from that, you might lose your ability to enforce things as initially written, or you might be exposing yourself to claims of discrimination for many reasons. And again, a lot of these I'm about to go into are things you want to avoid. These are pitfalls that will hinder your ability to enforce your documents. And all of a sudden now everybody's got these weird like hedges in front of their house because you didn't enforce properly. And again, selective enforcement is the kind of thing that can be raised as a defense, both in arbitration or in an actual lawsuit. And if they can provide examples of all these homes or units in their community that allow this violation to go through, yet they're enforcing against you, you're going to have a good defense against your association trying to enforce their rules if you can demonstrate selective enforcement. There's also estoppel. Estoppel is essentially saying, hey, I relied on X, Y, and Z, so you can't stop me from doing it. As an example, going back to the previous example, let's say I'm buying into a community, it's a no pet community, and one of the board members says, hey, we don't actually enforce this. You're allowed to have your pet. They send that in writing in an email saying, hey, don't worry about it. They move in, they have their pet, and let's say they suddenly get a letter from the board saying, hey, get rid of your pet. Well, this person says, hey, I bought into this community because I received in writing from a director saying I could bring my pet in here. That is estoppel. If you are changing your position, relying on another, that is estoppel. So make sure all your directors are on the same page here, because I have personally had situations where we have a tenant applying to a community. They reach out to the board saying, hey, are these requirements? Sometimes you have boards who are not fully aware of what your documents say, which they should be, and they tell the tenant one thing and another board member tells another one. Well, now you're creating a potential situation where somebody might rely on a board member who is a representative of the association, and that could kind of nip you in the butt later because, hey, when you go to enforce, they can say, oh, no, I have in writing that I could do this. So it's important that everybody's on the same page as to your rules and restrictions. Another one is latches, and I'm also going to combine basically latches in what's known as waiver, and the same thing, where it's important that when you see a violation, you enforce it. If you let things sit for too long, Let's say as an example, let's say someone had, they put a shed in their front yard or a basketball hoop in the front yard, and your documents say you can't do that. Let's say it's been up there for a year and a half, and a board member waits and says, wait a minute, we're not allowed to have those. Let's start enforcing. Well, they can have, let's say you're in court, all of a sudden you have an affirmative defense that you've given them, either latches and waiver, which are both essentially you waited, you sat on your hands. Latches is more so you had reasonable notice of this violation, yet you didn't take the time to address it. For a basketball hoop, you're probably going to see that pretty quickly. So your time period to deal with that is probably pretty short. Generally, I say both for latches and waiver, if something has been existing for more than a year, you might have lost your ability to enforce. Obviously, it's a case by case basis, and if you have a situation like that where you're not sure if there's waiver, talk to your legal counsel. But oftentimes, waiver and selective enforcement are the ones I see the most occurring because I'll have a board come and say, oh, the prior board, didn't really enforce this, but now we want to enforce this. Well, then I have to kind of pause and say, well, hold on, we have an issue here. Now, the slides don't go into it, but there are ways to somewhat fix these affirmative defenses I just discussed. And that's through a process known as republication. This is essentially putting everybody in the community on notice through like a letter to the community, board resolution, what have you, basically saying, hey, these certain restrictions were not enforced uniformly. As of this date, we will be strictly enforcing these things. And keep in mind, you might not want to hear this, a lot of times violations of the rules that were not enforced, they will be grandfathered in. So let's say you have a no pet policy in your documents, you've been letting pets in for years, you go to republish so you can start enforcing it going forward. Everybody else who had a pet before then, those pets are grandfathered in for the life of the pet. Now, they can't just suddenly go out and get new pets, but for anybody coming like a new owner or tenant, if they have pets, you can say, hey, if they try to say, oh, wait, but I see dogs over there, I should be able to do that. You can provide them with that republication notice and show, hey, as of, June 1st, no more pets. Sorry. On top of that, if you're going to amend your rules by adopting amended and restated rules, you're essentially republishing all of those rules that weren't enforced uniformly. So that's another option. I tend to like republication, but if you're already in the process of updating your rules, that can be another way to kind of revitalize things. But again, do keep in mind that people beforehand are likely grandfathered in. And republication, if you have a situation where you feel like your rules or restrictions haven't really been enforced consistently, I would talk to your legal counsel about what you can do to avoid any issues with enforcement that might prop up if you are expecting, an estoppel, selective enforcement, or waiver defense from an owner. Okay, so I know this is the kind of course where there's usually a lot of questions, so let's just jump right in. I see I got 33 messages in the chat here.
Yeah, but Chris, before you do that, let me reiterate to everybody, we'll get to as many as we can. We will likely not get to all of them. And I just want to quickly mention, too, that if you haven't already done so, press the chat button so it appears on your interface. We've already placed the link for the required evaluation in the chat. I'll do it again in about a minute. And then after you submit that evaluation, the following page after that showing a successful submission has a link to download and save the slides as well as Ace's contact info and Chris's and the firm's contact information. Lisa and Chris, back to you guys.
So Chris, I'm going to help you go through some of these. Or do you want to just hit them from top to bottom one at a time? Any way you'd like.
Oh wait, I think I'm in. I guess top.
Okay,
top
so
to bottom.
let me start with, and I'll try and get through as many as we can. Can the board appeal the decision of the fining committee in levying a fine?
So if the committee says no, your kind of appeal option is to basically restart the process. So let's say you levied a fine of $1,000. The fining committee was like, we think that's way too high, and they reject. Well, the board can then, begin the process again and maybe sit it at $500. But you still have to go through the first notice. The board has to re-levy the fine and then have a new fining committee meeting.
Okay, great. So there's another question that says, can tenants be members of the fining committee?
No.
No.
Unless your documents, for whatever reason, give tenants the right to be members, which I highly doubt, they have to be a member of the community.
What if the violation cured after fine set and before payment is due?
So if the violation is cured before the fine becomes effective, the fine It's gone. So this is fairly new, but they basically changed it where before, if the fine was levied by the grievance committee and notice was sent to the owner that the fine was levied, that was it. You can still cure, but nowadays they basically have until the fine would hit their account, so to speak, to cure it. Now, one thing I'll keep in mind, I didn't mention this in the body of this
Sure.
seminar, and something you should definitely talk with your attorney about is, unfortunately, when the legislator changed this enforcement section, they didn't really cover violations that are automatically cured. So, as an example, let's say Joe is smoking in front of in the lobby.
Yeah.
Joe leaves. Joe really did just cure that violation. So it's one of those things where can we actually do a violate? Can we level you a fine for this?
Right.
And for a situation like that, we suggest having a board adopt a fining policy that basically says for automatically cured violations, there will be an assorted, like a associated fine. Now, whether a court would uphold that or not, that is something we're still waiting on. But one way we recommend to clients to get around that is again by adopting a clear fining policy that addresses those types of violations.
Great. So we're going to try rapid fire as many of these as we can. Can we charge interest on not on unpaid fines?
Yes, you can. You can.
You
If
can.
your documents provide for interest to accrue on those fines, they can, but interest generally only accrues on assessments.
Great. What if a homeowner speeds on community roads disregarding posted speeds? Is that
So
something that
one
you can
thing,
find them for on private roads? Can we do that?
so if your rules or documents provide for it, sure. But if they don't, keep in mind associations are not police forces. It's not your obligation to enforce, the laws. Well, the association laws, yes, but you want to make sure that if you have those signs posted, your rules also cover like, hey, owners are to abide by the speed signs in the community. And if that's a common issue you have, and you have, private roads, you might want to consider talking to your local police department and having them enforce within your community.
Here's an interesting one. The front door has a key fob and a key. Can we suspend the key fob because they have other access? They can use their key.
So I would be careful. You
Yes.
don't want a situation where you suddenly have an owner you turn off the key fob to their unit and they don't have their key on them and they are locked out of their unit. You
Great.
can't really guarantee that they will always have access. That's a good one.
It's a
Actually a
good
good
one,
one.
which is, yeah, that's a
But
very good question.
I think the risk that an owner will be locked out of their unit kind of precludes
Yeah.
the creative aspect. That's a
So
good one.
when you can prevent somebody from coming through the residence side, right? And you can force them have to wait online for the guest side. You're
Correct.
not denying
Correct.
access to their house, but you are making it more difficult and they don't get to use their transponder,
Right.
right?
Right.
It's
Because
a,
at least
it's
when
an
you're doing that,
accommodation for,
exactly.
right?
Again, when you make them go through the guest side, that's always an option available to them. But with the key fob thing and the key to their unit, they might not always have their key. And now we
Right.
have
Yeah,
an extra issue.
Okay,
Just
so
a
rapid
couple of
fire.
one thing.
Yeah.
Patricia, Kelsey, others, the chat, technical issues only. Put your questions for the class into the Q&A. Two different
Yeah,
modules.
we're
Back to you,
getting through
Lisa.
as many as we can. Is the fine the responsibility of the tenant or the landlord owner?
It is always the responsibility of the owner, but the fines can occur due to the actions of the tenant.
Yes. So the owner is always ultimately responsible for their property. If their tenant is behaving badly and not following the rules, the landlord is always responsible for the damage caused, right?
Right. Owners are always responsible for the actions of their guests, occupants,
Right.
tenants, invitees, so on and so forth.
Can the association shut off bulk cable to a unit for non-payment?
I would recommend against it. And you don't want
Yes,
to touch
me too.
utilities on these
Yeah,
things.
utilities are a big deal. Okay. How can you fine or for trash cans left out if all they have to do is put it away before the fining hearing?
Well, again, that's kind of the issue we have with the way the legislature structured these things when they recently amended them. This is the kind of thing where we'd recommend having a clear violation policy where it says, if we observe your trash can being out more than 24 hours from garbage collection time,
Right.
that's an automatic fine of X dollars. Now, again, speak to your own legal counsel to get their opinion on this, because again, the statute kind of makes it clear that, or not clear, it basically says if it's cured beforehand, it can't be levied. But the problem is, I don't think they really, in Tallahassee, I don't think they really thought, okay, what about these things like the garbage can where they just put it away
Right,
or the
right,
cigarette
right,
smoke?
right.
So having a clear fining policy is a way to potentially get around those shortcomings from the statute.
Okay, next question. This is interesting. Someone has a fob which is now suspended, and they enter a clubhouse. What can be done if someone let them in, let the person whose access has been shut down, they're being let in by their neighbors or their friends?
Unfortunately, this is not really much you can do about it. I would recommend maybe sending a letter to the person who let them in, saying, "Hey, please don't let in this. Any residents need to have valid key fobs to get into the clubhouse. We've observed that you let us an individual in who doesn't have, authority to enter the clubhouse because their fob's been suspended. Please stop, or you may be subject to fining. So treat it like a violation."
Yeah, so I happen to be the president of my own HOA, and we recently have I had an issue with an owner because they literally let a guest in every single day, the same person. And when we locked the door and you needed a key fob, they caused such a ruckus, pounding on the door, demanding to be let in. I'm like, you don't live here. You
Yeah.
don't live here. Okay, let's see. What else do we have? Suspend use of rights. Is there a minimum amount due if not addressed in docs? I'm not sure I understand that question. We're going to move on. For suspending the voting rights, the board has to vote on that at a meeting, correct?
Correct. Correct.
Correct.
And it can't be less than $1,000.
It cannot be less than $1,000?
Right. If the amount owed is more than 1,000, then you can suspend the use rights or voting rights. Excuse me.
Okay. If a fine is levied to a board member, can the board suspend the board member's voting rights? That's a good
That's
question.
a good. That's a good question. I would say no. I mean, they could suspend their voting. I guess they could suspend their voting rights, but
Yeah.
keep in mind that a board member who's delinquent for more than 90 days is off the board.
Okay. So
So
board
if you have a
members who
situation where
are
a board member has been living for more than 90 days, you don't only need to
okay.
suspend their voting rights. Well, you could suspend their voting rights, but their position as a board member is gone. It's over. It automatically terminates. It's not a temporary thing either. They are off the board, and the only way to get back on the board is if the compliant board members put them back on.
Wow. Okay. So that makes a lot of sense.
Pay your
That's
dues.
helpful. Um, okay, so somebody said they want a class just on Kaufman language, so we could do that. We definitely can put that on the calendar. Maybe over the
Be
summer
pretty technical.
in our summer series, Chris. I just volunteered you. I voluntold you. So you're going to do a class on
That
on
is
Kaufman
just a warning
language.
to people who are asking for it. That is a very technical class.
Okay. If an
Bring a
owner
pillow.
files
Boring.
a fair housing complaint, Jeff, take note. Is
Boring. Boring.
pre-suit meditation and mediation an option?
Well, sorry, repeat the question.
I'm sorry. If an owner files a fair housing complaint, is pre-suit mediation an option?
So I haven't really seen a HUD investigation require mediation, but to file the complaint, you don't have to do pre-suit mediation first. That can be done at any time. Same thing for condos. You can file a complaint with the DBPR before even doing pre-suit mediation. So it's
Great.
only for those disputes I mentioned earlier, that's only when you have to do it if you're looking to file suit later.
Great. We're facing turnover from the builder in 2 weeks. They didn't enforce any rules. Now, can the first homeowner board enforce?
So it's probably a pretty new community. I don't know how long developers had control, but this
Don't
is one of
know.
those things that I would just to be safe, the moment the new board steps in, you send a letter to everybody kind of introducing yourselves and saying, "Hey, here's our rules. You already have our governing documents. We will be enforcing these going forward."
Great. Okay. Is there a 4-year statute of limitations on violations not enforced? is that when you are grandfathered?
So statute of limitations, it really depends on what the dispute is. I couldn't give you a general catch-all for everything, but when it comes to waiver and flatches, if something's really been sitting there for more than a year, it's kind of a baseline. That's when you should really talk to your attorney before proceeding and can maybe consider republication. As to an actual statute of limitations, I couldn't tell you off the top of my head what it is. I know for at least for contract disputes, which the governing documents are a contract, it's 5 years, but you're going to have a waiver a lot sooner before the 5 years.
Okay. What can a board member do when the majority of them do not want to enforce our docs that say no trucks?
Well, if the majority doesn't want something, well, unfortunately, there's not much you can do other than maybe if you're authorized to do, speak to your own legal counsel. And again, be careful to, incur attorney's fees on this. But
Right.
if they need to have your counsel remind the board, like, hey, if you don't want to enforce this, just keep in mind you might waive your right to enforce this into the future. But unfortunately, if the majority doesn't want to do something, that something's not happening.
Okay. Do you recommend a fining menu of predetermined fees to maintain consistency among violations? Yes. I'm not an
Yes.
attorney. Don't play one on TV. And the answer is yes.
And
Right?
consistency is always good. Again, when it comes to
Yeah.
selective enforcement, consistency is key.
Okay, we're going to take a few more. I just want to be respectful of everybody's time. It is 12 o'clock, top of the hour. For those of you, Chris, you can stay a few more minutes, keep answering questions. But for those of you that have to go, Jeff, you want to briefly just give, I know you've been putting it up and in the chat, there you go. After you submit the evaluation requirement is completed and you can sign off if you want to. If you are a CAM, if you are a board member, you need to fill out that evaluation to get your credit. Okay. Do you need to have HOA street posted speeds if the community has posted speeds?
That's something you probably want to talk with your insurance about. When it comes to these private roads, the speed signs aren't, at least my understanding, aren't enforceable speed limits. Obviously, if your documents provide that, hey, you need to abide by these, you have a basis to enforce them on. But if these are public streets, obviously those street signs are, they're posted by the municipality, so they do have weight.
Right. Okay. What can we do if no one wants to be part of the fining committee? We're a condo.
Unfortunately, this is a very common thing when I'm, advising clients on the fining and suspension process. A lot of times they tell me, hey, we can't get 3 people. And unfortunately, you need those 3 people. We're trying to ask Tallahassee for alternatives, but unfortunately, for now, you have to have the committee in place. So for situations where you don't have the
Yeah, my question to you is to follow up to that. What if the board wants to take that on and just vote on all of it? Are they entitled to do that? No, it has to be a fining committee.
by law, you have to have an independent committee. And unfortunately, if you don't have that committee, well, then you can't fine or suspend for rule restrictions. You can still suspend for delinquencies after the 90 days, but the fining and suspension for violations, unfortunately, to get compliance, you would need to talk to your legal counsel and have them start sending some nasty letters.
Okay. This one is interesting because economically, I think this is something that all communities are dealing with now and may deal with more in the future. What happens when a homeowner files bankruptcy to stop lien enforcement? They were also delinquent on their mortgage.
That's something you need to talk with a bankruptcy attorney about.
Bankruptcy attorney.
Generally speaking, though, when bankruptcy is filed, a lot of times those responsibilities stop while they're dealing with the plan. But I am not a bankruptcy attorney, so I would suggest you speak with one.
Okay. If in litigation with a homeowner for various violations, can the board still send a recommended fine to fining committee to proceed with a fine against that homeowner?
Yes. These are not
Additional
like you pick one.
violations, right?
Right. This is not like a pick one lane and you have to stick to it. If an owner is violating while a lawsuit's going on, you can still continue to violate, or excuse me, enforce.
Okay. What can be done to prevent the pool being used by outsiders?
Well, you can put up. It's one of those things where if you see a violation occurring and you don't know who it is, I wouldn't just run up to someone and say, "Hey, who are you? Like, you don't live here. You don't want to like threaten people or make people feel unsafe." But if you observe people that you don't recognize and you see, oh, they're going into this unit, they must be a guest, and they or a tenant, and we don't know who they are. well, you treat it like a, an unapproved occupant if that's something your docs provide for, unapproved tenant. But otherwise it's pretty hard to enforce. Unless you know everybody in your community, it's pretty hard to suddenly say, hey, that person doesn't live here. The main thing though, again, if you have restrictions against these things, you have to go back to the owner and enforce against the owner because they're allowing these violations to occur.
Okay. Um, how do you approach sharing fine committee names? I find most do not want their information made readily available to the community.
Well, unfortunately, they're going to know who they are because these committee meetings are open to the members. So anybody
Right.
can attend these. Um, Generally speaking, as well, a board, when they create the finding committee, they do it by a resolution, which would have the committee members' names on there. It's Unfortunately, it's a public position.
Can you
Again,
have
we were
more than
trying to get
three?
Tallahassee to help us out on this, but
Okay. Can you
it,
have
it,
more than three people on the fining committee?
you can, yes. But I
Um,
always recommend an odd number, and three is kind of the minimum.
Great. What can we do about an owner riding his motorcycle in his backyard, especially at night?
Sounds like a nuisance to me. So a nuisance violation, which almost, I would say every documents have, but I recently came across some documents that actually don't have this in there. But nuisance is kind of the catch-all thing where an owner's being annoying, or they're doing something that might increase insurance rates, or they're doing something illegal. It's nuisance. And speak with your attorney about this, but nuisance is generally if we don't see something on point, we can kind of point the nuisance. If this guy's riding his motorcycle in his backyard at night, that sounds like a nuisance to me. And it might even
Great.
be a noise ordinance. There might be a lot of things you could do to stop this person.
Um, so this is a question. If two board members have not paid their maintenance fees over 90 days plus, one is the vice president. President has not done anything and other board have looked the other way. What can be done? They are running again to be on the board. I think you answered this to some extent, but maybe you can clarify.
So again, if they are delinquent after 90 days, they are off the board. That's it. You can tell them, hey, per your ledger, you have been delinquent for more than 90 days. Goodbye. On top of that, if somebody's running for the board and they have any delinquency as of the date that it could be eligible for candidacy, so for condos, when they put in their notice of intent for the annual meeting, or HOAs, they cannot be nominated from the
Wow.
floor if they have any delinquency. So these board members you mentioned, if they are delinquent, they cannot run again. And in fact, if they have been delinquent for more than 90 days, they're off the board as well.
Okay. In an HOA, once the fine reaches $1,000 aggregate and a lien against the property has been filed, is there any other action that can be taken if the violation continues to exist?
You can do more fines. Just because you levy a fine once doesn't mean you can't start the process over again and levy more fines.
So
But generally speaking,
the $1,000 aggregate allows you to file the lien for the $1,000 and then the process starts all over again with new
right,
violations?
right. So let's say you did the fine was levied, they didn't pay within 30 days. You then follow your collections process with your counsel, and if they violate again, you can send a new notice saying, "Hey, we we see this violations occurring again. We're going to be levying more fines, and we will include it in our lawsuit when we move to foreclose."
Wow, that's good to know. I didn't know that. Um, okay, if I'm just going to do one or two more and then I won't hold anybody any longer. And I really appreciate you taking some extra minutes, Chris, to help answer
No
as
worries.
many questions as possible. Um, if we have lots of violations in our community, can we send out one letter to all owners as this is a notification warning for all listed violation below for the year of 2026? Further violations will result in a fine.
You can, but it's not really kicking off the process here. Again,
It has
we
to be
want
individual
specific,
letters to individual homes, correct?
right? If we want to proceed with the finding process, you need to be sending individuals things out. Now, if you notice a lot of people are violating a specific thing, this might be the kind of thing where you send out, hey, we've as an example, I have a community where they have very clear assigned parking for owners and then very clear guest parking, and owners cannot park in guest parking. Well, wouldn't you know it, a lot of owners have been parking in guest parking. So we sent in a letter saying, hey, this is a reminder that you can't be parking in guest parking if you're an owner, and if you continue to do so, you may be fined or you might even tow your vehicle. So that's certainly an option to kind of put people on notice. But once we're going to actually start towing particular vehicles or fining particular owners, that's when we send them a specific notice.
Okay. We're going to do one more question. Well, two more. So this question is, to what extent does information concerning fines need to be kept confidential to the board, not discussed or made available to the general membership?
There's very little things in fining that's going to be confidential.
Right.
So the notice to the owners, part of the official records, the minutes of the board meeting where they levy the fine would be a part of the official records, and the minutes of the committee hearing would also be in the official records. So there's not really any confidential things. If we're dealing with like medical stuff, then that really shouldn't be a part of fining either. So I couldn't really see a situation where there'd be any confidentiality here.
And then do you have to send a notice before towing if parking in visitor parking? Right?
You really should. You should at least put a
Then
sticker on there. Make sure you have proper signs posted saying that cars might be towed. You list the vendor who's doing the towing. If you're considering towing, I suggest you speak with your towing vendor or get one if you don't have one, and your insurance to make sure your property is set up to properly tow so you're not running into issues later.
And then also for ARC board members, if anyone on the ARB, the Architectural Review Board, if they, or committee, however we have ACB, whatever your acronym is, if they are delinquent or, also for that 90 days, are they also off that board or committee or chairperson or any other function in the association?
That's a good question. I wouldn't say they're automatically off, but the board, even if they don't have delinquency, have the authority to take them off the committee. But the statute only provides for board members if they're for board members that are automatically off. I don't believe it has anything for committee members.
Do you have to publish a list of fines before you fine anyone?
Like a list of like the people to be fined.
Right.
So what I suggest to people, because it might be awkward, is so let's say you have the board meeting coming up where you're going to be discussing levying fines. You put on the agenda discussion and levying of fines for non-compliant owners. And when the item comes up, you can be vague and say, either a unit number or, we've observed, these units, we're going to be levying a fine for this amount, or suspension for this time period. But then make sure the minutes reflect the actual identification. So you can put in like unit 113, owner Joe Smith can be in the minutes, but when you're actually speaking the stuff at the meeting, you can say, this unit 113 has a violation for X, Y, and Z. You don't need to say names or anything.
Okay.
And this reminded me of something. This reminded me of something real quick before we sign off. Never post a list of people who are suspended. So let's say you suspended someone's pool rights. Please do not post at the pool, Joe Smith is not allowed here, and you put his photo up. You are just setting yourself up for a lawsuit here.
Public humiliation.
Don't do it.
Don't do it.
I don't even like the idea of publicly stating who's in arrears, right? I think that is private information. I have board members that want to see that happen, and I said, as long as I'm president, that'll never happen. I think it's depending on the culture of your community, right? I'm very grateful we don't have many, literally very few, but I just think that, and I stand up at board meetings and I say, if you're struggling for any reason, please reach out to us, because if the delinquency goes to the attorney, we can no longer speak to you.
Just be happy your associations are not
nice. Attorneys aren't nice.
Yeah, just make sure you're not part of an association during the time of Game of Thrones, because you'd be made to walk that walk of shame down the mountain. Shame.
Honestly, the red wedding.
Don't do that. Please don't do that.
The red wedding was enough for me. I needed to see nothing more. Chris, I cannot thank you enough for your time, attention, your expertise, and sharing.
Thank you for having me.